On the desk in my office is a document entitled State's Motion to Dismiss in the case of State of Idaho versus Rita Nancy Hutchens. This is a document that was extruded from the printer and excreted from the foul personality of a man named Shane Greenbank. Shane L. Greenbank, once known as Shane L. Greenbank Ivy. There perhaps is an interesting story here in the fact that this man has had two legal names. He is, in any case, the deputy prosecutor for the Bonner County government in northern Idaho. He had formerly been a deputy prosecutor in Kootenai County, which is right next door. On one memorable occasion, a mistrial was called during Mr. Greenbank's opening arguments. This was about 5 years ago, in a domestic violence case, because Mr. Greenbank, apparently playing from the Jimmy Swaggart songbook, started to cry as he was listing the allegations against the defendant in this domestic violence case. This document has to do with the prosecution, or the attempted prosecution, of Rita Nancy Hutchens, who is a quilt artist from Sandpoint, Idaho. She moved to Idaho, I believe about 25 years ago. She is, if memory serves, 57 years old. She spent a little less than half of her life in Sandpoint, Idaho. She's a refugee from New York. She came to Idaho in the winsome, if misbegotten, expectation that she would be left alone. She ended up, over the last year and a half, or a little more than a year and a half, probably almost 2 years now actually, ended up entangled in one of the most grotesque examples of petty, vindictive municipal corruption I have ever beheld. This document is dismissing a case that was filed against Rita Hutchens for battery. Let me read the document, and then I'm going to go back in and supply the critical details that this well-compensated liar by the name of Shane Greenbank has omitted. Comes now Shane Greenbank, Chief Deputy Prosecuting Attorney for Bonner County, State of Idaho, and moves the court for an order of dismissal. This motion is made pursuant to Idaho Code Section 19-3501. Said code section requires a court to dismiss a case if a misdemeanor defendant isn't brought to trial within 6 months of his or her arraignment, unless good cause is shown. In this matter, by the state's calculation, speedy trial ran as of 8/1/13, that is, August the 1st. It's interesting that Rita was told as recently as the Monday before this document was submitted, before this was filed, that actually this was filed on the 6th of August. She was told on that day that they were going to court 2 days later, on the 8th of August. She had an 8th of August trial date. They planned to proceed with the trial in spite of the fact that the speedy trial timeline had expired as of the 1st of the month. While an argument could be made that good cause existed to expand the statutory time frame due to the defendant's previous warrant status and overall noncompliance with multiple court orders, the right to a speedy trial is much too important a right enjoyed by all our citizenry to be offhandedly brushed aside, and therefore is not an argument that will be made by the state in this matter. This is a victory in the sense that they have spent 1 year in focused, concentrated persecution of this innocent woman because she is planning to file a lawsuit against the city of Sandpoint, Idaho, and the county, Bonner County, because of an incident in which she was beaten up by a police officer on her own property. And this exercise of officially sanctioned violence was later ruled to be illegal by a judge. The judge ruled that the police officer had no right to be on Rita's property, that Rita had no responsibility to talk to that police officer, that the arrest was illegal, and that Rita was not to be held guilty of the supposed crime of resisting arrest or obstruction. She'd actually been charged with obstruction. So Rita was injured in that police assault. She filed a notice of damage claim against the city. The city turned down that notice of damage claim, so she filed a notice of tort claim that she was going to take the city and perhaps the county to court for redress of the injury that she had suffered. While researching that claim almost exactly 1 year ago at the city hall, Rita found herself being harassed and mocked and ridiculed and obstructed by people whose salaries she helps to pay. So in disgust, she left the office and was informed later that she was going to be prosecuted for criminal battery. Of what did that battery consist? It consisted, allegedly, of Rita battering a deputy city clerk by throwing a pen at the city clerk, but not throwing the pen directly at the clerk. This was not an instance in which she was using the pen as an impact weapon by beating the clerk or as a projectile by throwing it at some vulnerable portion of that clerk's ample anatomy, but by throwing the pen down at a desk. It ricocheted off the desk and struck the clerk in the arm, inflicting no noticeable injury to anybody. This was considered an act of criminal battery. It was on that basis that Greenbank and his comrades have been after Rita Hutchens for a year. This is Will Grigg with Freedom Zealot Radio. Stand by for more sedition after this. Welcome back to Freedom Zealot Radio. I'm William Grigg, author and proprietor of the Pro Libertate blog at freedominourtime.blogspot.com. freedominourtime.blogspot.com. At Pro Libertate, some months ago, I wrote extensively about the persecution of Rita Hutchens by an ambitious and thoroughly contemptible figure by the name of Shane Greenbank, who afflicts Bonner County, Idaho, as the chief deputy prosecutor in the county prosecutor's office. Before that assignment, he had been a similar affliction to the residents of Kootenai County, which is a neighboring county in the panhandle of Idaho. Rita Hutchens has done no injury to anybody in her entire life. That's not to say that you couldn't find, if you excavated deeply enough, evidence of traffic citations, or perhaps even so-called narcotics offenses. In other words, things that she has done that inflict no injury upon other people's persons or property, but are regarded as violations of what the government pretends to be the law. She was accused of battering a city clerk a year ago in the Sandpoint City Hall in a rather unpleasant confrontation involving research that Rita was doing into an injury inflicted upon her through criminal violence exercised by a Sandpoint police officer. She had not, that is to say, Rita had not done anything to justify any attention from the police. She was the owner of a rental property, the tenant on which was being evicted. This was in November of 2011 that this occurred. This tenant was a deadbeat, and so Rita, exercising her right as a property owner, arranged for the eviction of that tenant. The day before this episode took place, the tenant had been arrested by the police on warrants, outstanding warrants. That doesn't mean that the tenant was a criminal. It means that the tenant, herself, had come to the attention of the police. When Rita drove up to the home to see if the power was still on, if the lights were on, the water was still running. This is winter, remember. She had to be concerned about the possibility of pipes freezing and such like once the house had become abandoned. She noticed, Rita did, that the tenant was on the front step of the home talking to a police officer. Quite understandably, Rita did not want to get involved in whatever was going on at her rental property, so she drove away. She returned about 20 minutes later, and the conversation between the deadbeat tenant, the soon-to-be evicted tenant, and the police officer was still underway. And so Rita left again. She was going to wait until the police officer was gone. She drove by this house that she owned as the landlord on two separate occasions. She was in a public street. She was not doing anything that could be construed as menacing or threatening. Yet the tenant said, that woman is harassing me. And on the basis of this fleeting and not terribly credible allegation, the police officer followed Rita home. And once Rita got to her home and stepped out of the car and started to stride toward the entrance of her home, the police officer said that she needed to talk to Rita. And Rita said, "I've got nothing to say to you." That ended the matter. The police officer had no probable cause, no warrant, no justification to pursue the matter further. Instead, the police officer assaulted Rita from behind, threw Rita to the ground, handcuffed Rita, and then tried to invent some reason to justify that action. There's actually a recording of a conversation between that officer and that officer's superior in which they are reviewing the statute book trying to find some reason to arrest Rita. They settled on obstruction, took her to jail. Rita was injured in that assault. She, of course, suffered the irreversible injury of being handcuffed and kidnapped at gunpoint. 6 months later, a magistrate judge threw out the obstruction charge, ruling that Rita had acted within her constitutionally protected rights by refusing to speak with the police officer. That led to Rita's request for compensation from the city, which was turned down by an official in the prosecutor's office. Obviously, somebody who's part of the same prosecutor prosecutor's office that had tried to put Rita in prison for a bogus charge is not going to compensate her or to authorize compensation for the injury that had been inflicted by the city government. So Rita filed a notice of tort claim and was researching that issue, the legal claims that would arise from her arrest, her spurious and illegal arrest, her abduction once again, last August, that she was involved in this incident in which a pen she supposedly threw ricocheted off a desk and hit the body of a city clerk, inflicting no injury. Nonetheless, the city government, aided by the county sheriff's office and the entire machinery of official persecution in that part of Idaho, decided to make an example out of Rita. This is a woman who had filed a potential lawsuit against the city because of injury she had suffered, so what better way to get rid of this than to make her a criminal defendant? Well, perhaps the one better way would be to have her committed for psychiatric care because of her supposed instability. And both of those tactics were employed, and they really differ little, if at all, from the tactics that were used in Brezhnev's Soviet Union. Now, Mr. Greenbank in this document states that, to begin with, once again, from the section of this document dealing with dismissal of the case, the right to a speedy trial is much too important a right enjoyed by all our citizenry to be offhandedly brushed aside, and therefore that is not an argument that will be made by the state in this matter. The argument in question having to do with extending the period in which to pursue this legal matter further. He says, though on the third psychological evaluation report declares the defendant able to assist counsel in her own defense, the report fails to provide a description of the nature of the examination and a diagnosis or evaluation of the mental condition of the defendant, both of which is required by code. Coupling that with the defendant's behaviors and conduct throughout the pendency of this matter casts serious doubt on the defendant's true ability to actually assist her counsel in her defense, in the likely event that she actually allowed appointed counsel to assist in said defense, as she has adamantly refused counsel throughout this case, in fact only conceding to appointment of counsel in order to get out of jail for refusing to comply with the court's second order of evaluation. Let me unpack that a little bit because the diction is terrible. Mr. Greenbank is a government employee, which means that his skill set does not include functional literacy or rudimentary ability to compose coherent sentences, so I'm going to have to translate and to provide useful context for what he's trying to say here, or saying rather ineptly. There are 3 separate orders for a mental evaluation that have been filed against Rita Hutchens. Not a single one of them was justified. For reasons having to do with her own personality and her own beliefs, she's refused legal counsel because she did not want to pretend that this was a legitimate legal proceeding. There are all kinds of irregularities on the part of Mr. Greenbank and his comrades that I think validate that concern on the part of Rita. 3 mental evaluations. She's refused to take part in any of them and has been sent to jail on contempt because she has refused to put herself in a position where she could be incriminated. Mental evaluations of this sort are usually ordered after conviction or after counsel has been assigned. They're not used in this manner unless the objective is to try to find some reason to force the person into a mental institution against his or her will. Let me skip forward in this letter and explain to you why I believe, or to illustrate from what Mr. Greenbank said, why this was the strategy. While it is unfortunate that the psychological evaluation did not result in some treatment recommendation that may benefit the defendant, I'm just going to take that clause and orphan it from the rest of the sentence here and underscore that. It is unfortunate that the psychological evaluation did not result in some treatment recommendation. He wanted to get her into a mental hospital to dispose of the matter that way. That is a purely Soviet tactic in Sandpoint, Idaho. I'll be back in just a minute.